Hello, hello. Ahí estamos. So, sí, nos escuchan bien. Espero que nos estén escuchando. So, hoy vamos a hacer un poco diferente. We're also going to be speaking Spanish, by the way. We're in California, anyways.
Yeah, that's right.
Here we speak two languages. Hablamos español y hablamos inglés.
That's right.
Depends where we go.
Depends where we go.
Okay. So, my name is Edwin Rivera with the Millennial Realtors, and I have here Juan Castro from Chicago Title. If you can see him, tiene el pelo bien blanco, but that's experiencia, sabiduría, como decimos por ahí. Thank you, Juan, for
Yes,
coming to
thank
our
you.
office today and be on the live today. So today is going to be a hot topic.
Yes.
You know, a lot of people buy their home, they go into title, you know, because one of the things when you're buying a house is choosing how to take titles. And it's multiple ways.
Yeah.
And to tell the truth, even me as a real estate agent, I have a good understanding, but it can be super confusing, you know, and something you choose one option without even knowing if it is the right option for
Right.
you and your family, right?
Yeah. In fact, when you most of the time people by default are given what the escrow actually does or the document. So many people don't even have an input when they do it. So,
I know.
yeah.
Okay, so let's go in, let's dive in. And anyone, if you guys watching us through Facebook, Instagram, YouTube, or even TikTok, put a comment below. If you're here, just saying hi to us. If you have any specific question about title, feel free to ask those questions. So we're gonna be here, you know, sharing all the knowledge as possible. Okay, so how to take title. So when you're buying a house,
Yep.
it's like you can say buying a car. You know, you're gonna have a title. It's gonna be one owner buying that specific property. So now, when it's multiple owners, you have different ways to take title.
Correct. Correct.
Okay. So let's say the most common one is joint tenants.
That's correct. That's correct.
Talk to us a little bit more about joint tenants.
Okay, so as Edwin mentioned, there's a variety of different ways to hold title. There's some advantages on some and some limitations. But let's talk about joint tenancy. So it is the most commonly used for most people that are buying it with two people. Okay.
Uh-huh.
And the reason why joint tenancy is popular, again, usually there's more than one person buying it, especially a husband and wife, domestic partners, and or even individuals. The joint tenancy, one of its advantages is that it avoids probate when there is a decease in one of the joint tenants. In other words, joint tenancy has the right of survivorship, which means that the person that's a joint tenancy will automatically get the property and avoid probate.
Okay. So let me see if I get it.
Sure.
So technically, when you do a joint tenant, is two people or multiple people buying the house. Can be
Correct.
multiple people.
Yes, sir. Absolutely.
Okay, can be multiple people. If one other person pass away,
Correct.
the surviving person will own the property, right?
Correct. And it's assumed that the amount of people, 2, 3, 4, 5, that ownership is owned equally.
Equally. Oh, okay.
So that's how that joint tenancy works.
Okay. Now, a big question on that one, and probably you will answer my question
Sure.
too. When you do joint tenants, it has to be husband and wife. It could be between brothers, it can be between sister, friends, depending how you buying the property.
That's correct. Absolutely. Doesn't have to be husband and wife. That's the most common. But Edwin and Juan Castro could buy a piece of property as joint tenants.
Oh,
Now,
okay.
being that Edwin's married and he has his lovely family and I have mine, most likely Edwin will most likely not want the property to go to Juan.
Okay,
And so there we go into another type of ownership.
type of ownership. Okay, so technically, joint tenants doesn't allow you to pass the title to your kids or another family member.
That is correct. That is
Okay.
correct. In fact, if we, in our instance, and we'll just move us into the next one, if we're partners and we buy a piece of property, and I know Edwin's savvy and he has a trust and we have a trust, the tenants, the trust owning together will automatically be tenants in common. There's no such things as two trusts owning as joint tenants.
Oh, okay. So now that you mentioned that, so another way to take title on the property is going to be tenants in common.
Correct. Correct. And
You don't mind? Let me take the jacket. With this crazy weather,
Yeah. On and off.
Hey,
on
look.
and off.
I don't know if you see, but here's está el sol pegando.
This is the latest and the greatest sun right here.
I know, like it's supposed to be
Rainy.
rainy.
And
I brought
pouring.
my jacket. I even bought a scarf, umbrella. I don't need it right now.
No.
Hey, by the way, if someone tonight me atropella with this sweater, trust me, it wasn't an attempt of suicide, suicidio.
Yeah, yeah,
Yeah, there's no way they can tell me I don't see you.
That's funny. That's
Yeah.
funny. He's a walking guard on his other part-time job.
Yes, and by the way, let me say hi to a few people. Está Jose Ventura, Andrea, they watching us through Instagram. Also Giovanni and Javi. So hi guys. Any question? Feel free to write your questions on the comments. Okay, let's go back into it. So the second way of owning property was tenants in common,
That's
correct?
common. And that's a common way when two individual people either have the interest in different amounts. You could be 70-30 and be tenants in common. And the fact that you want your interest to go to your direction to the next level, to the next person. So people would hold tenants in common for not having the right of survivorship.
Okay. And also, if you are married, like nowadays, divorce is 50% rate. So
Yep.
there's a lot of couples who get remarried.
Right.
They already have families, and a lot of they choose tenants in common because now if you have your own kids, then your portion can go to your own kids.
That's correct. That's
Okay.
correct. Now, of course, if you are tenants in common, and let's say again, me and Edwin own a property in tenants in common, Edwin could choose to own his portion in a trust so that if something was to happen to Edwin, it automatically goes to the children, and we're still tenants in common. Now I'm with your trust.
Okay, I see that. Okay. Now, what happened if one person passed away
Mhm.
and you don't left someone on tenants in common, and you don't leave someone as who will be the next person? What happened to that portion of title?
Well, that portion of part is now probated. So that estate will no longer go to your inheritance. It will now have to be discussed through the process of probate.
Okay, and we're gonna discuss too what expo. Just a quick, brief explanation. Probate. So when you pass away, and they don't know where the title will go, even though you might be married, you might have kids with the next person in line. The court will do a probate. What it is the court will take over the title of the property in a way, or will make decision for the title of the property. You have to go to court on that case, and it's an extra expense also for the family.
It is. It is. It's somewhere
And it's a
between.
long process as well.
Yeah, it could be somewhere between 20%, 30% is what the normal what we see. And what happens is you will have to petition, even though you're married. I know people would say, well, it's community property, I'm married. But unfortunately, title is very important. That's why we recommend that whenever you are in that position, to seek consulting through a CPA or an attorney. That would be your best bet.
Okay.
But in this case, let's go with the fact that something was to happen to you or I, we're tenants in common. You or I, one of our family members would have to go petition the court for the administrator to get appointed administrator of the estate, and they'll go through the process. And like you said, depending on the amount. Now, probate is an amount that is needed for it to go to probate. So
Okay.
a full probate would be, I believe, the amount is $160. So if the property has $160,000 in equity, not necessarily at the sales price, bless you, but equity, then that
Thank you.
property would go into a full probate.
Okay, I see that.
There's a dollar amount here in California.
Okay, perfect. So anything below 160.
Still a probate, but it's expedited faster.
Okay.
Yes.
Now I have a question. Going back to joint tenants.
Yes.
So what happened if it's dad and mom
Mm-hmm.
on as joint tenants?
Right.
They're the only two entitled,
Mm-hmm.
and they pass away
Simultaneously.
simultaneously, like car accident. Hopefully nothing happened to anyone
Right.
like that, but it happened.
But life happens. Unfortunately, if they didn't have the property in trust and both passed simultaneously, that would go through probate as well.
Okay, I see that. Now, a third way to own property is a trust. Okay, and we've been mentioning that word a lot.
Mhm.
So a trust is similar to a will, but anything in the state of California above 160,000, a will would not help. Correct?
Correct.
You have to have a trust. It's not something you grab a paper and start writing. Mi casita se la dejo a
Right.
Panchito. Nothing like
Un
that.
testamento or will, as you're mentioning to, will not avoid probate. It
Okay.
will help the process, but it doesn't avoid it. because at least we have a document that gives us the last wishes, what the judge will actually take into account what the wishes were.
Okay, but you still have to go to probate.
That is correct.
Okay, so a trust technically is a document. It's like a will,
Mhm.
but it's a document that you go to a lawyer. So a lawyer or paralegal has to fill it out. It's
That's
a legal
correct.
document, and that you have to record as well. Correct.
That is correct. Great point. Great point. Having a trust doesn't necessarily mean that your property is going to avoid probate. The title, the actual legal document that gets recorded at the county recorders, has to be in the name of the trust.
Okay.
Okay. In fact, I'll talk a little bit about if you have a trust and you fail to actually put it in.
The camera.
There you go. If you have a trust and you fail to actually put the property in title of the trust and don't record anything, we now call that a Hegstead. HGGSTEAD, a Hegstead Act. And what that is basically you had a trust, but unfortunately the document was not executed and recorded in public records.
Oh wow.
Yep.
And what happened when that happened?
Well, you know what? There's a lot of rumors and stuff like that, but remember that the county recorders reviews your chain of title. So when document gets recorded, they see it. Back in the day, the title companies, we would use heir documents. We would get all the heirs together. They would agree on something, and we would be able to vest through, as we call it, or convey real estate. A while ago, I forgot when Hegstead came around. It looks like the probate attorneys made a good point about a break in the chain. So this break in the chain was, hey, how is it that Juan Castro, yes, I know he wasn't in trust, but all of a sudden transferred into, his heirs without any trust being recorded. So now we have to go through a Hegstead, and it is very similar to a probate. Now, again, the trust is there already so that the judge could actually see what the wishes of the individuals were, who the beneficiaries were, and away they go. They most likely will appoint the beneficiaries as administrators of the estate.
So, based on what you're saying, if you open a trust, to me, it's one of the best way, if not the best way, to hold title.
Yes.
And there's multiple benefits that we're gonna be talking about, but make sure you record that because I seen it where they do go to a lawyer, go to a paralegal, do the trust. They keep the book, they never record.
Right.
But what happens if you have a fire? What happens if something happened and that document get lost?
Wow, that's another great question.
And
that happens a lot.
It happens a lot.
Your father, your mother, they have it, they secure it, they put it in a place where they don't tell anybody. And if something happens to them, here we are scrambling looking for it. Is it important to have it? Absolutely, because only the trust has the information that title needs to make the decisions of who will now be the trustee of the trust. The original settlers are the people that created it. They're the trustors. Usually they appoint themselves as trustee. And in that trust, they also have named who the successor trustee is. In case either by incompetency, resignation, or death, they appoint someone that says, I want this individual to now be the person in charge or executing my wishes in the trust.
Okay. And the beauty about the trust, by the way, is something that you can not only pass the property to someone, but you can put specific conditions. You can be specific of that. Like what happened if, like, for example, I have 3 kids.
Right.
What happened if it happens something to me and my wife?
Correct.
And then my kids are minors,
Right.
I don't want the property to go to them or the person who's going to take care of them. They can sell the property, waste the money. So you can put a specific conditions on the trust that can protect your kids and your wishes to be,
Exactly. And I think when you sit down with a trust attorney, paralegal, or anybody who prepares it, those questions will get asked about what you want the wishes to do. And we talk about kids, children, or anybody under 18 really should not be holding title.
Yeah.
Because they, by California law, cannot actually represent themselves. So if you add your child that's under 18 because you think, oh, this is the best way to secure, to make sure they get it, and they're under 18, unfortunately, if there is a need for them to sign something, we would have to go to court to get them to be approved for that.
Okay. We're going to come back with more subject about a trust, by the way.
Okay.
Okay, so we already talked about joint tenants.
Yep.
We already talked about tenants in common.
Correct.
There's another one is community property.
Correct. So community property in California, when you're married, there is a community statute about when you're married. So there's a community property. But there is the way you could actually own property in community property as husband and wife, and with the right of survivorship. So the community property, what's nice about that is you could convey your property. If you own property as community property and someone passes, it automatically goes to the next person. It is kind of another way of joint tenancy, but it's has a little bit more, and this is where your tax man comes in, has a little bit more advantages over the joint tenancy if you are married.
Okay.
So I would probably recommend, if you are married, that community property with the right of survivorship be your choice. But again, CPA, tax attorney is your best bet.
Okay. Home ownership, if you're buying a property now, if you're buying the home on your own, do you have different options or not?
Not necessarily. I think what happens is if you've never been married, it would be a single man or a single woman on title.
Okay.
If you've been married, you'll see something like a unmarried man or an unmarried woman. Okay. Also, married people could take on title by themselves.
Okay.
Okay. So in that case, they would be like Juan Castro, a married man, sole and separate. Now, in that sole and separate, that just means that one time when I took title, my spouse went ahead and signed it and agreed to the terms.
Okay. And by the way, and that's kind of common. And when let's say it's a married couple and only one person is on the loan,
Right.
for X reason, either because of credit or finance situation.
Right.
When that happened, the bank, in most cases, if the second person is not on the loan, they won't allow them to be added to the title.
And vice versa. If they're on the loan, most likely they're going to want them on title.
Yes, unless they're like a non-occupant co-signer.
Correct.
And that's another subject with a lender.
Correct.
Okay, perfect.
Good points.
Let me see. Okay, deed. Now, if they bought a home, they join tenants or they're tenants in common. My question is, can they switch it?
Good question. Absolutely. You could switch your vesting anytime. Title would not be involved in helping you do the transfer or changing title. You would most likely have to go to an accommodator. Call Edwin, he's got that info. And what you can do is say, well, we're tenants in common and now we want to go joint tenancy because maybe our relationship is a little bit more established and we decided that I do want my portion of the property to go to my significant other.
Okay. Now, this is a good advice. When you buy a home, let's say someone bought a home back in 2017, mom and dad as an example.
Mm-hmm.
Something that I see a lot is they switch title, but not exactly to go to joint tenants to come in tenants,
Okay.
but they switch title just to add their kids.
Yes.
They think they're doing something good,
Right.
but they might be affecting your kid and they might be affecting them as well.
Correct.
Okay? Because let's say they bought the home, I don't know, like in the city of LA for $400,000.
Correct.
And probably the property taxes is based on 400,000, 1.2. It's gonna be what, around 5,000,
Annual.
5,500.
Makes well sense. Yep.
Okay.
Yep.
So now, when you technically, there's a law right now that in LA County, as an example, they can only increase 2% or it's in the whole state of California.
Prop 13, 1.25%. You got it. Under 2.
Under 2.
Under 2.
Okay, is the state of California or is by county?
State of California.
Okay, perfect. So technically, even though your property is worth $900,000 now, they cannot increase the property taxes based on the $900,000. They can only do a 2% increase annually max. Okay, so that's the reason you don't see a huge change on the property taxes, even though the value of your property is completely different. But if you add your kids, that's a change of title. That would trigger a new assessment on the property. So that means if you bought a $400,000 paying only $5,000 and something on taxes, now they can reassess it back to the $900,000.
Today's market value.
Today's market value. My apologies. That's para el otro lado. I got a new camera, by the way.
the whole switchboard is amazing.
Yeah. Standard. I think it's this. It has a motion, so I think it's pulling my hand.
I got
But the thing is like showing my mesh. There you go. I think that should fix it. Let's see. All right. We're in the middle?
Yep.
Yes. There you go. Okay. Where I was?
So,
Oh, yes.
adding child
Adding
and
the
assessment.
child. So you have a reassessment. So now they can assess it to market value. If at that moment it's 900,000,
Correct.
so that's being 1.25. Now your property tax from 5,000, they can go above $10,000,
Almost doubled.
almost double. And then you ask your question, well, why the payment went so high out
Right.
of nowhere?
Right.
Okay, so that's one of the mistakes.
Yes.
Okay.
Yes.
Now, if you want to add someone to title, like your kids, as an example, because if you're getting old and something happened to you, the best way to do it is through a trust.
That is correct. That is correct. Avoiding adding your children, as Edwin says, is many reasons. One, as we're recognizing, is the taxes will go up. Now there is a Prop 19 that actually will even, if you like, we can touch a little bit on it. So Prop 19 basically came around in February 2021, and the rule basically replaced and repealed Prop 60, 90, 158, 60, 90, 58, and 193. So it took away all those, and 19 actually took over. There is a parent to child transfer that is allowed to avoid reassessment, but it has to be the parent's principal resident, and the child has to make it their principal residence within a year.
Okay.
So that's the new Prop 19.
So technically, if the dad is 6 years old, the kid is his son or daughter is married, have their own house with their own family, it won't apply.
They won't apply because in their kids, that is an income property to them because they already own another home.
Okay.
Yes.
I see. And there's another one.
Yes.
Mistake. Well, no, I don't want to call it mistake, but there's another reason why we don't advise to add kids.
Yeah.
Usually, the reason car insurance is more expensive for kids or people who are less than 25 years old is because they usually have more car accidents. Now, when you own a property, even though you say, hey, I'm going to add my kid just in case something happened, they can keep the property. But if your kid had a car accident, as an example, the expense is more than what the insurance can cover. Now, probably if they sue that person, they can go after the property.
That's correct. You put the property in harm's way because the child now has an asset, and people that have been sued, if you have an asset, they're going to go pursue it. Even an IRS tax lien, a state tax lien, a judgment. They don't pay their credit cards. As young people, we're just happy-go-lucky people. We don't understand being, the adulting, the word being used today. And you fail to do certain things that you're not responsible enough yet. And unfortunately, when you add your child, that property is being impacted now.
Okay. Yeah. That's a good advice. And that's a common one that we see
all the time.
Bastante.
Okay. Yeah, it happens often. But common sense says, yes, let me add my child, no different than, let me add them to my Christmas list or add them to this or that list. A lot of people do it, but it is a common mistake.
Okay. So now, going back to the probate, probate, is when technically, just a refresh. When someone passes away, you don't have a trust, or if you have it in a specific way of ownership, it can go to probate. So what it means is it's going to go through court in order to sell.
Correct.
Okay. Usually, when you go to probate, the first people who get paid is the creditors.
Right.
If you have credit cards, if you are medical, usually the state charges whatever they give for medicines, medical, etc.
That's correct.
Before they give it to the kids.
Yes.
Someone passed away recently, and the home was sold and was through a probate. So what's the singer?
Aretha Franklin.
No.
Prince.
I think it was him.
You would think that these people would have it and
have
advisors. They would tell them.
They sold the property, and almost 30% was lost on the probate.
Yes.
And that's $1 million property.
and $1 million, probably tens of millions of state that goes into it. Guess what one reason why people don't put their properties in probate?
Se les olvida?
Procrastination.
There you go.
Procrastination. They just say, it's not going to happen to me. I'll do it later. And later sometimes comes sooner than you think.
I know. Yeah. And it's not cheap because you have to hire someone. Mm-hmm. Paralegal might be close to $1,000 more or less. If you go to a lawyer, I heard it's between 2,000 to 3,500.
Correct.
But you can also add multiple things as well. Bank accounts. You can also add.
All your insurance policies, your bank accounts, your financial investments, and all your properties. To be quite honest. Yeah, all. Not just
Okay.
one. Yeah.
So yeah, so if you own a property, speak to your real estate agent. See what he's gonna tell you, but speak to a lawyer, or you can call us. We have here the expert Juan Castro from Chicago Title. He can give you what are the benefits from one to another one. You can rewatch the video. Okay, so this.
Yeah, and we can send you a link of all the apps so you can have it as well.
Yeah.
English and Spanish, and by the way, Chinese as well.
You have a Chinese now?
Yeah, we do.
Okay.
But I don't speak it. It's LA. I should. Nowadays, everybody speaks
Oh yeah.
multiple languages. I
Right
think
now-
that's my next one.
Right now, we have a client that is trying to lease a commercial industrial location, and most of the landlords they're having difficulties. I'm having difficulties speaking to them
Yeah.
because they speak Chinese. We
Yeah.
use our app translate the best we can.
And by the way, at my office, we do have some Mandarin and Chinese speaking and Korean. So if we needed to have that kind of dialogue and you're interested, we could actually have someone help you out with that. Too.
Okay. But yeah, if you have any questions, first of all, thank you, Juan, for coming today.
Thank you for the invitation.
Appreciate it. So hopefully all this information was great for you guys regarding how to hold title. I know it's something a lot of people don't talk about it. Even when you're buying a house, they don't talk about it. They just send you the form and say, choose one.
Exactly.
At least us, we go over with our clients, hey, this is the different options. We
Right.
don't advise them because the best thing to do is speak to a lawyer,
Yep.
But we tell them, well, we advise them, open and trust the moment you can. It's difficult to do it when you buy in the house.
Correct.
But the moment you purchase the home, it has to be one of the first thing you need to do the moment you buy the home.
That's a good point. That's a
Okay.
good point.
So yeah. So thank you so much everyone for watching today. Thank you, Juan, for coming again.
My pleasure.
And we're gonna have it more often. A lot of propositions regarding title in California have been happening the last few months, the last few years. So we're gonna talk about them
Yes, sir.
little by little.
Let's do it. Looking forward to it. Thank you.
Perfect.